noticed that politicians struggle to enact the things they run on, that regardless of who wins elections, lawmakers find they cannot pass whatever legislation they like. They find themselves bound by what is popular, or at least their sense of it. They can only act within a narrow set of ideas, and that range is called the Overton Window. And on the Overton Window podcast, we look at issues around the country and talk to the people who change what is politically possible. Now, there was a recent Supreme Court ruling that said that the president cannot just decide to pay off student debt by himself. He needs an act of Congress to do it. And, well, I kind of wonder what that means to the other thing that the president did on this issue, which is to defer student debt payments at his own discretion. During the early parts of the COVID crisis, Congress passed legislation that said students didn't have to pay their student loans, and their debts wouldn't grow during the pause. But after that expired, the president said that this deferment goes on until he decides to end it. So today I'm joined by an attorney who is challenging this. Sheng Li is the litigation counsel of the New Civil Liberties Alliance. But I also want to know about what this means to the broader question about the shifts in the balance and separation of powers. Sheng, welcome.
Hi, James. Thanks for having me.
Can the president defer student debt payments at his own discretion?
Well, the Supreme Court pretty much said no in handing down the Nebraska v. Biden decision. Look, I mean, that decision, again, dealt with the one-time $500 billion cancellation. It didn't deal with the pause that's been going on. But if you read the dissent closely, Justice Kagan pretty much said, hey, the reasoning of the majority opinion would also shut down the student loan pause.
And that's why she doesn't think that they should have done it, though.
That's true. She would have preferred both policies to be to continue, but I think she understands that if one falls, the other does as well. And perhaps, I don't know if your listeners would enjoy a little table setting here, but just by way of background, when the COVID-19 pandemic hit back in March 2020, the Department of Education decided to put a pause on all student loan repayments. So that meant if you were a borrower, you didn't have to repay your loans on a monthly basis like normally you did. And perhaps more importantly for the Treasury, interest stopped accruing on your loans. So essentially there was a monthly cancellation of loans equal to the amount of interest that accrued. That pause has been going on for over 3 years now. And the CBO that's the Congressional Budget Office, has estimated it costs about $5 billion a month. If you add that all up, it gets pretty close to $200 billion of interest that just never accrued on people's loans.
So it's a huge fiscal policy that the president just decided to make at his own discretion.
Exactly. And what's interesting is that at the time, nobody thought to challenge it, even though it was incredibly expensive. And it hurt a lot of businesses' bottom lines, including businesses whose job is to refinance student loans. So you have, like SoFi and other banks that make money by taking your student loans and repackaging them and giving you a lower interest rate. But they can't beat zero. So, they stopped getting that sort of business.
Well, let's talk about that. I mean, someone did decide to challenge this. You did. Why?
We did. And it was interesting that it lasted so long, for so long people just didn't challenge this. And it actually, to be honest, I just think it wasn't on folks' radars to challenge until last year, in 2022 August, when the president announced an even bigger cancellation policy, where he said, I'm going to use an authority under this statute that he found from 20 years ago to wipe out between $10,000 and $20,000 of student loans, just completely wipe out, not a pause, just canceled for 40 plus million borrowers. And that was going to be estimated to be between 400 billion, some say 500 billion. But at that point, they say it starts to add up to real money. And so when that policy was announced, a lot of folks challenged that cancellation, including NCLA. And that's the case that was the Supreme Court finally decided. But it's only I think it was that challenge when the president kind of maybe jumped the shark and did something that really got on people's nerves and brought those challenges that then everyone said, wait a second, there's also this pause that's been going on. That seems to be problematic too, especially when the president justified the pause under the same statute that was used to justify the 2022 super one-time forgiveness policy.
Yeah, so my understanding of this whole thing is that when congressional authorization expired and the president just decided to keep doing this thing, a lot of people said that looks very suspicious, but we're just not sure who could challenge it even if they wanted to, because this is like a classic concentrated benefits diffuse cost issue, which is, we know who's benefiting from this. Who it's costing? Does it cost anyone in particular? Can you just challenge this? That was a more difficult question.
That's
so
right.
Even though a lot of people thought that this doesn't look like the president can do this, a bigger question is, okay, but who can stop him?
Yeah, I was hoping we wouldn't go through the judicial doctrine of standing, but here we go. And one of the you're absolutely right. One of the reasons it took a while to get these policies challenged is this doctrine called standing, which says you actually can't go and challenge a federal policy unless that policy injures you in some way, and certainly we believe that And the way that this policy worked is that because it benefited student borrowers, they weren't the ones being injured. So the question is, who is being injured? And I think,
besides basic principles of separation of government.
Exactly. So for the one-time policy, the Supreme Court said, well, you have servicers such as this Missouri agency, a servicer that gets paid by the government by the number of loans they process and service. They're injured because if you forgive a bunch of loans, some of them are going to go to zero, and some of those accounts will be shut down. And if the company is, being paid per account per year, then it's getting paid less, and that financial injury is sufficient for standing. Now, I would argue that again, as I mentioned, these refinance companies had standing all along. Because nobody's going to take advantage of their services if their loans are getting canceled. Nobody's going to take advantage of their services if they don't have to pay interest on their loans. And yet, they didn't sue for this many years, even though they were taking hits on their bottom line. And that, I think, has less to do with this concept of judicial standing and more to do with sort of more kind of political balances. And I think if you're a bank and you may have probably all your employees have student loans, or at least your new hires have student loans. Many of the media was very pro alleviating student loans. So even if it's illegal, even if it hurts your bottom line, maybe you're not inclined to trigger public ire to help your own business. But that may have changed when I think they saw the public turn, both legally and in popular opinion, turn against the president for trying to just wipe out $500 billion of loans at the same time.
I mean, do you think that when they started doing this, they considered the risk that they would simply have their authority revoked through Supreme Court action? I mean, it requires speculating about motives and what people think, but I mean, it seems like a pretty extraordinary decision to just say, I can spend whatever I want to when most spending has to get passed through Congress.
Yeah, and in fact, all spending does. This is this is Article 1 makes that pretty clear. And I want to go back a little bit in that and say the Supreme Court said the president doesn't have the power to forgive student loans en masse. And that was portrayed in the media, I think, as a sort of a controversial decision. You had this 6-3 split with Republican appointees on one side and Democratic appointees on the other side. And there's a lot of debate about the wisdom and the content of the cancellation policy. But I want to kind of remind listeners that the Supreme Court's decision actually had nothing to do with the wisdom of student loan cancellation or the specific content of the Biden administration's policy. And in fact, in many ways, that decision may have been the least controversial of this term, arguably, because all Justice Roberts' majority opinion did really is reiterate what Democratic Speaker of the House Nancy Pelosi said in 2021, and I just pulled her quote up here, and she says, "People think that the President of the United States has the power for debt forgiveness. He does not. That has to be an act of Congress." That's essentially what Justice Roberts said too. So I don't think it's a very controversial decision, and in fact, in grade school and high school, civics classes everywhere, students are taught the separation of powers in our Constitution, and that under Article 1, new laws and new spending must come from Congress. So how are you going to appropriate money to pay for $500 billion? You have to go through Congress. You can't do this without Congress. And so it's just not a controversial, idea that the president doesn't have unilateral power to forgive loans. And which then goes back to your other statement about, well, why did he do it? and I think he knew he couldn't do it. And the reason is he asked Congress first. He campaigned on canceling loans, and when he got in office, he repeatedly asked Congress. And only when Congress repeatedly said no, did he then go back and say, oh, actually, there's this 20-year-old law that nobody really paid attention to that gives me this power all along. So if he really thought he had this power, why would he waste all this time asking for Congress instead of just unilaterally acting in the first place?
Yeah, and I think you were talking about the reaction to that court decision that said the president doesn't have this power. And I think it really, this is my media platform. I get to shout it from the rooftops. This means that Congress can't, all this means is that if you want student debt payments, you have to pass it through Congress. That seems like a pretty basic thing. The takeaway from this court decision should be that if you want student debt payments, you have to pass this through Congress. Congress remains in control of fiscal policy of authorizing federal expenditures. This should be what all that we're talking about in reinterpreting this. But that's not actually what I'm hearing from media's outlets outside of this one. Can you tell me about the reaction to that decision?
Yeah, and I'm really, I share your frustration and confusion at this. And it should be. There are many, if student loan cancellation or some types of relief were really popular, you would see voters, pressuring their representatives in Congress to enact some kind of relief. And, I'm not against that. That could be. There are many borrowers who are struggling, and perhaps there's a way for Congress to kind of figure out how best to address that. But the problem is Congress is actually in a really good position to do that because they can look at what the federal budget is, look at at the time there was a looming debt ceiling. What does that mean? How much can they spend because of that? And what are all of the national priorities and figure out where student loan cancellation fits into that, and they can target it towards the people who are in most needing of it. Whereas what the administration did is, let's talk about the August 22 policy. It was just a one-size-fits-all policy. They drew a line that says, well, we don't want to give the super rich, a handout. So if your household makes more than $250,000, you don't get it. But if you make $247,000, you and your wife together, then you get this benefit at taxpayer expense. That seems a little problematic. And the studies have looked at that and found that this really benefits some of the upper income individuals much more than lower income ones, many of whom didn't graduate college, and other lower income borrowers even, who actually have other ways of getting forgiveness, such as the income-driven repayment plan that says if your income is low enough, you don't have to pay as much. So those guys were getting some.
Let me stop you there.
Benefits already.
This is an important point I want to recapsulate, which is the president just decided that he was going to do this, have this plan. The plan had whatever features he decided, and if it went through Congress, it probably would have looked very different. But it was just an arbitrary presidential rule that said, "Okay, I'm taking this power and I'm spending money in these particular ways," which is an explicit thing of saying that Congress, who was supposed to be better attuned to the popularity of their constituents, should be more sensitive to these things. Whereas if you just let the president do it, it's probably not going to be as targeted, at least.
And Congress did act on this when that pause, the interest and repayment pause was enacted. That was actually Congress. Secretary DeVos did it first, but 2 weeks later, Congress says, that's okay. We're going to do it too, and that was legal. They enacted a 6-month pause because at that time during the pandemic, nobody knew what was going on, and Congress made a deliberate decision that 6 month is whatever that cost is the amount of money that's whatever groups benefit. That's where the chips fall. And they made it. That decision was that not only would the pause last 6 months, but it would not last more than 6 months. It was a very set end date, and that was a judgment of Congress reflecting voters. Whereas then, it was actually Donald Trump who decided, you know what, I'm going to extend this. And then when Biden came into power, it's like, I'm going to extend this too, over and over again. And that pause actually, in some ways, is even more unfair than the proposed cancellation that was struck down by the Supreme Court, because number one, it didn't have an income cap at all. You could be making $1 million a year and you didn't have to pay interest on your loans. And number two, because the benefit was directly proportional to the amount of interest you would have to be paying, the people with the highest amount of borrowing benefited the most. And those were people who took out very high loans to go, like myself, who went to law school and medical school and got out and were making very high salaries. First year associates at big
law school and medical school.
Well, not that group of people did. Like first year associate salaries were rising throughout the pandemic, and I think it was.
And that's another thing that it's part of the federal loan programs. Is that an undergraduate, there are limits about how much you can borrow. On the graduate level, there are no limits.
And it's sort of, that was also a congressional decision, and it sort of makes sense in that if you're borrowing money to study, an art history degree at Oberlin, maybe you're not going to pay that off. But if you're borrowing money to go to, Harvard Law School or something, you're a pretty good bet to pay off your loans. And ultimately, it was the Center for a committee for responsible federal budget. They analyzed this and they found the average law student who benefited from this got about $40,000 of benefits from not having to pay their interest, whereas the average undergraduate not having to pay their interest only about $5,000. The average associate's degree about $2,000, and for the really people who really need it, those are the people who never finished their degrees, dropped out, and were saddled with debt. They got even less. So it's just a very untargeted policy that if you ask Congress to provide debt relief, one would think they would have reached a different sort of balance.
Yeah. So I do want to try to reiterate that point a little bit, or encapsulate it in a different way, which is, both Congress and the president are trying to find ways to benefit the public with their actions. And they think that, and the president at least thinks that even outside of congressional authority, he's got a plan that is going to help some people who need help. And in this case, the plan that he came up with isn't especially targeted at people who need help. That is, like there may be some people who struggle with their debt payments. That matters very little to the plan that he came up with. And so that. And if we had gone through the normal process of congressional approval, it probably would have been targeted more at people who need help. But I think this kind of comes back to the broader point that I want to get to, which is this was the president just saying that he has the ability to spend money without congressional authorization, something that seems like very few other presidents have ever tried, and the Supreme Court, at least when looking at the debt payment portion of his plan to help student debt, said that he did not have this authority. Is that a win for separation of powers?
Oh, for sure. I mean, look, the Constitution places spending powers in Congress for a reason. It's not like a formality. The framers were trying to prevent essentially the presidency from becoming a king. Remember, before the Constitution, there was the Articles of Confederation, which didn't even have an executive branch. That didn't work out, so they decided, well, we need to have an executive branch, but we need to put safeguards. We just fought a war to escape tyranny, to escape a king who can tax and spend however he wants. They decide what they need is put, these guardrails to prevent that sort of abuse. And one of those is to ensure that the power to spend money is separated from this office they feared that could become an office used by a tyrant. The power of spending money is separated from that and put into the most politically accountable branch of government, the legislative branch, specifically the House of Representatives, that's directly elected by the people. And because otherwise, if the president could spend money as much as he wants, he could do what King George was doing, which is to give royal largesse to his cronies. Obviously this time was cancellation of debt, but that's not really any different from just taking money and handing out cash. Because imagine because if you can just cancel debt, that's from an accounting perspective, it's identical to putting dollars into one's bank account. In fact, that's partly why this policy was very popular among student borrowers.
And you said this is something that it's not especially partisan. President Trump did it, and President Biden have done it. Have there been some other examples of presidents just saying, "I have the authority. Don't worry about it. I'm going to spend money how I want"?
Yeah, I mean, I guess less so with just. This might be the most outrageous example in that it was directly taking money from taxpayers and giving it to a favored group, which seems particularly outrageous. But there are kind of bipartisan, especially in the COVID era, bipartisan violation of the separation of powers. For example, it was during the President Trump's administration where he extended a ban. Again, Congress enacted a temporary ban on evictions nationwide. Because at the time, no one knew how COVID was going, but it was meant to be temporary and it expired. And then President Trump extended it over and over again. And then when President Biden came into power, he extended it over and over again. And it got to the Supreme Court, and the Supreme Court said, hey, this looks really fishy, please don't extend it. gave the President Biden an out. Just don't extend it and we won't rule against you. And then, lo and behold, a month later, President Biden extended it again, and the Supreme Court said, well, you forced our hand, and had to shut down that eviction moratorium. And I imagine that's we might see something of the same, because after the Supreme Court just ruled against this particular loan cancellation policy, the Biden administration over the last week has announced several new student loan initiatives that are essentially trying to backdoor around the Supreme Court holding and cancel loans in other unlawful ways. And I can't imagine the federal judiciary will be pleased by that.
Mm-hmm. But it's part of this broader trend, which is like we all learn the basic principles of separation of powers in our high school civics courses, and this is an essential part of the American system. And yet, that separation of power seems to have eroded an awful lot, almost to the point of irrelevancy. Although not to irrelevancy, as you can see from this. I mean, is this just a couple of steps to putting the genie back in the bottle and really making these separate and distinct branches of government that have separate and distinct powers?
Yeah, I think so. And one of the things the Roberts Courts has been doing over the last, I would say maybe 4 or 5 years, has been more clearly delineating the respective powers of the branch of the government. For the first time, really strengthening those guardrails for the first time in maybe 50 or 60 or 70 years. I think partly because it's the administrative state and executive branch has, they've been given a lot of flexibility by prior courts, and I think they've maybe overstayed their welcome or overextended a little bit, you're seeing a reaction by the courts to cabin executive agencies to their to more constitutionally appropriate roles. And one of the doctrines that's grown from this, it's what's called the major questions doctrine, which says if an agency cannot generally act on its own to enact a policy that has a major political or economic consequence, unless that agency can point to specific and clear congressional authority. And this is a reaction to Congress over many years have delegated used very broad language to delegate regulatory power to the agencies, and the agencies have, seized upon those some broad delegations to say, aha, we can do X, Y, and Z, which clearly, we wouldn't think Congress actually gave them this power. And just an example for this particular case, the statute at issue was this 2003 statute that Congress enacted called the HEROES Act. That's a reaction to the wars going on in Afghanistan and Iraq at the time, saying, look, service members and people affected by war and similar sorts of national emergencies may have trouble paying off their student loans. So what we're going to say is the Secretary can waive or modify provisions of federal student loan statutes for people affected by, I think it's war, military operations, and other national emergencies. And so, in one sense, that could be a very targeted sort of, narrow statute for, if you're going abroad to fight terrorists, or if there was an attack in America and you lost your home and your job, something like that, you can get some student loan relief. But you didn't think Congress, at that time, by the way, it was all of them. I think it was passed unanimously, or it was maybe one dissenter. You wouldn't think everybody would have said, well, actually, what we meant to do is to give the Secretary of Education, unilateral the authority to control $500 billion or more, and give that back to whenever they want.
Yeah, I think that's interesting. That's worthwhile of having that clarification that's out there. And the loophole that Congress is taking is that they say, look, we're passing a law, and we're explicitly giving the executive a bunch of different authorities within the legislation that we pass, and that's one of the reasons why presidents can feel like they can do whatever. And there are actually political reasons why that is. Like, a lot of congressmen don't really want to be held accountable for the precise things that may not be popular in order to attain the ends that they're requiring from the administrative agency. Like, and this is one of the problems that we have with this convolution of the separation of powers, is that, one of the reasons why they've eroded is because Congress doesn't want to legislate. That's hard. What do you say to them?
Yeah, you're absolutely right. And I think, I think there's law review articles being written about this, because for the last century, before this turn in the Roberts Court, I think the courts relied on Congress to police the boundary between the executive and legislative branch, under the premise that, well, if the executive branch is encroaching on Congress, Congress will fight back, so there's no reason for the courts to really get involved. But what the courts have kind of learned is that's not what happens at all. Instead, what happens is that if you're an individual congressman, you would love to just delegate broad power to the executive agency, so you don't have to make hard decisions. Instead, you don't want to have to run for election, or worse yet, nowadays, run for primary on a legislative record, because legislation typically requires compromise, and again, those sort of hard decisions. And if you compromise with the other side to pass a law to solve a problem, the flank, whether you're left or right, your flank is going to be mad at you because you didn't give them everything they want. In fact, you couldn't have passed the law if you gave them everything you want. And so then you're going to get primaried. You're going to face a harder election if you have a legislative record. Much better to go on Twitter and scream at people than to actually accomplish legislation. So Congress is happy then to shirk their legislative responsibilities and instead let the executive branch take action. If the executive branch takes an action that they like some extreme action they like, that's great. You can point to and say, "Hurrah! We gave all these student borrowers a ton of money. Vote, look how good our party is." And if the executive branch does something you don't like, again, you can go on Twitter and scream about it, and that's sort of how you get donations and voters out to the polls. So there's this political dynamic that I'm not sure what to do with, but the courts have certainly found it to be frustrating, and have started acting to, because everything. We can think of these rulings as against the executive branch, the court stopping the executive branch from doing X or Y. But one other way to look at it is the court's telling Congress, hey, do your jobs. Like you can't let the president in power do it, and you have to go and do it yourself. If you want student loans, enact a student loan debt relief program. If you want more environmental protections, enact more environmental protections. We're not saying you can't. We're just saying you're the one who must do it. You can't put that responsibility on someone else.
If you want to ban gas stoves, you have the ability to pass legislation to ban
Precisely,
gas stoves. So I think it's not just Congress who doesn't want to legislate or take over some of those powers. I think a lot of our fellow citizens think it's great that presidents get unlimited authority to do whatever they want, at least when their guy is in charge. And I mean, to me, this is like an obviously partisan, obviously wrong, and that we should do something about this. The separation of power stuff is really important. But this partisan desire to defer to the president is something that does extend from the Capitol to the White House. As in, like when it's your guy who's doing the determining over what power it is, you want to give him all the authority in the world to do whatever he wants. So are legislators ever going to go back to insisting upon their constitutional mandate to legislate, or is this something that like courts are just going to have to force them to figure out how to do?
Well, certainly the courts have started to force them, and I think it's only been a few years, so the jury's out. But I feel like there's actually been quite a few legislative compromises in the last few years that have been accomplished. Whether it's you may disagree with some of the content, but we saw like the Infrastructure Recovery Act. We saw the debt ceiling negotiation come through with some sort of compromise. We have, for example, a hot button culture war topic, gay marriage. Gay marriage, there was the statutory provision, a protection for gay marriage, which I think people would have thought 10 years ago could never happen because it was such a hot button culture war topic. But now that the Supreme Court has basically said we're going to let legislatures, whether it's state legislatures in abortion cases or whether it's federal legislature in student loan or vaccine mandate sort of cases, that this power belongs to legislatures. We've actually seen some legislative progress in maybe not all the things we each voter wants, but in things where Congress could reach a consensus.
So you and your colleagues are really trying to invigorate this basic civics thing that I think we all should think is important. You've got a bunch of cases that have been challenging the automatic authority of the administrative state and the broad tendency to let the executive branch be the officer, enforcer, interpretation of law. You've had some success on this, right? I mean, this has been something. We
have, yeah, and it's been very encouraging the last few years. Not just our organization, but our allied organizations as well, bring these cases up, and it's. I think the federal judiciary is more receptive to these arguments, in part because I think the executive branch in regulating and in adjudicating have pushed the envelope so far that there's a growing consensus around the notion that they've gone too big for the breeches, I guess.
How does it feel to be making a difference in this really important area?
Oh, it feels terrific, and being part of this process, and it is slow. It's because working on these things is a case by case. One precedent builds upon another. This student loan decision didn't come from just itself. There's been a line of cases, at the lower courts and in the Supreme Court applying the major questions doctrine, applying textual canons of interpreting statutes that led to this outcome, and so each victory that's maybe broadcast by the media. I think you can look behind that and you can see there's probably dozens of cases that maybe don't get so much attention, but are as very important to that overall result.
Sheng, thank you for coming on to help us understand this issue, and good luck in your efforts to shift the Overton window.
Thanks, James.